Chapter 5 Introduction to Contracts. Learning Objectives. Specify the elements of a valid contract. Specify when an offer has been accepted. Recall the requirements to prove that there was fraud in a contract. Recall the rules pertaining to mistakes in contracts. Specify when a contract is considered to be unconscionable. Identify the rules pertaining to the evidence of terms relating to a contract. Recall the rules pertaining to the assignment of contractual rights. Introduction contracts are a key concept in business, so we have set aside a chapter to address their essential elements. This includes such matters as contract contents, the ability of a party to enter into a contract, breaches of contract, and the assignment of rights. One must have a solid foundation in these concepts in order to mitigate the litigation that sometimes accompanies contracts that are not settled to the satisfaction of all parties. Sources of contract law. There are two primary sources of contract law. One is the Uniform Commercial Code, UCC, which is a legal code that applies to commercial transactions. The UCC was formulated in 1952 and has now been ratified by nearly all of the state governments of the United States. Some provisions of the UCC have been adopted by every state, thereby harmonizing laws pertaining to commercial transactions across the country. The code is divided into 9 articles, which cover 1. General provisions. 2. Sales and leases. 3. Negotiable instruments. 4. Bank deposits, collections, and fund transfers. 5. Letters of credit. 6. Bulk transfers and bulk sales. 7. Warehouse receipts, bills of lading, and other documents of title. 8. Investment securities, and 9. Secured transactions. The most important contract law in the UCC is Article 2, which covers sales and leases. Another source of contract law is the Common Law of Contracts, which is compiled from court decisions that have subsequently become established precedent. Most of these precedents are derived from state court decisions, with only a limited number of decisions coming from the federal courts. The provisions of the UCC generally take precedence over the common law of contracts. Nature of contracts. A contract is an agreement between two parties that creates mutual legal obligations. It does not have to be written, but oral contracts are not recommended, since it is more difficult to legally enforce an oral contract. A valid contract must contain the following elements: an offer and an acceptance of that offer. A promise to perform a valuable consideration. A time or an event by which the performance must be completed, not here completed. Not when started. Terms and conditions for the stipulated performance. The actual performance. Introduction to contracts. 30. For example, a buyer offers to pay a seller of widgets $500 for the delivery of 40 widgets with a double coating of green paint, as long as they are delivered by March 15 to the buyer's facility. As an example of an alternative scenario, Mary pays Albert $10,000 not to sell his farmland to a property developer during the following one-year period. In this case, the performance is negative, since Albert is being paid not to do something. The existence of a contract is decided in part by examining whether a reasonable person would conclude that the parties to it intended to enter into a contractual arrangement. For example, I will renovate your bathroom for $15,000 sounds like a contract offer, whereas are you interested in selling that plot of land does not. In the latter case, the statement made is no more than an invitation to negotiate, rather than a contract. Offer acceptance. An offer can only be validly accepted in an unequivocal manner. This means that a statement of acceptance can have only one possible meaning, without any exceptions or conditions. For example, Angie offers to sell her road bike to Victoria for $1,000, to which the response is, "I think I'd like to buy it, but let me think about it." This response constitutes hedging, and so cannot be construed as an acceptance. Note: As long as an emailed acceptance to an offer has been made in an unequivocal manner, it is a valid acceptance of the offer. An offer is only considered to have been accepted when the offeree accepts it without any attempt to modify the offer. When a modification is proposed, this constitutes a counteroffer, and so cancels the original offer. For example, a machine tool manufacturer offers to sell a lathe for $5,000, which the offeree accepts under the provision that the manufacturer include a 5-year warranty. The demand for a warranty creates a counteroffer, and so voids the original offer. An offer is not assumed to have been accepted when the offeree does not respond. This keeps an offeree from being held liable through an action. For example, an offer to sell the offeree a car for $35,000 by Saturday unless the offeror hears otherwise does not constitute a valid acceptance. However,
That was certainly interesting. And now, for something completely different. Now
let's briefly discuss fraud. A contract is void if one of the parties to it engages in fraud. Fraud is a false representation of the facts, resulting in the object of the fraud receiving an injury by acting upon the misrepresented facts. Thus, when one party to a contract misleads the other party through a fraudulent misrepresentation, the other party's consent to the contract is not real, so it can be voided. To prove fraud, the plaintiff must prove all of the following. There was a false statement of a material fact. The perpetrator knew that the statement was untrue. There was intent by the perpetrator to deceive the plaintiff. The plaintiff relied on the statement, and the plaintiff sustained an injury as a result of the preceding actions. Though a successful plaintiff can rescind a contract and recover damages from the other party, it is entirely possible that the funds have been shifted or the perpetrator cannot be found.
Alright, question number 12. A valid contract must contain the following elements, except for, which means 3 are correct and 1 is incorrect. Okay. A start date for the performance, a promise to perform, terms and conditions for the stipulated performance, or valuable consideration. Now again, which one of these is not necessary?
I believe it would be a start date for the performance, because it should have a completion date.
It needs a completion date. Because there's less control over the start date. Very good. All right. Lucky 13. Why don't you read the question and tell us the answer?
Okay. The following situation indicates that an offer has been accepted. A. When the offeree does not respond. B. When the offeree issues an acceptance that is lost in the transmission. C. With a statement of acceptance that has 2 meanings. D. When the offeree accepts it with a modification. Well, I believe that would be maybe letter A.
No. Think about this again. Remember, what if somebody accepts it and uses old technology like a fax machine, and it gets lost or it goes into the recipient's junk email? Is that whose fault would that be?
It would be lost in the transmission.
Lost in the transmission. You understand the difference?
Sure.
He did respond, or she, or the company, but if it's lost in transmission and it's exception, and the other person can go in their outbox, I accept it.
Sure, it just got lost and it's situational.
Okay. All right. All right. How about number 14?
Should I start?
Yes.
A situation in which both parties agree to render the stipulated performance at the same time is known as A. Condition subsequent, B. Contemporaneous condition, C. Conditions precedent, or D. Concurrent conditions. Well, I believe obviously the answer is letter D. Concurrent conditions.
Concurrent condition.
Concurrent conditions.
Concurrent conditions.
Okay.
This is a negative question.
Okay. To prove that there was a fraud in a contract, a plaintiff does not need to prove the following. A. The plaintiff relied on the statement. B. There was a false statement of a material fact. C. That the plaintiff's position did not improve because of the defendant's actions. Or D. That the perpetrator knew that the statement was untrue. I believe the answer is C. To prove that there was a fraud on a contract, a plaintiff does not need to prove the following. Number A, that the plaintiff relied on the statement. B, that there was a false statement of a material fact. C, that the plaintiff's position did not improve because of the defendant's actions. Or D, that the perpetrator knew that this statement was untrue. I believe the right answer is C.
Very good, because the plaintiff's position decreasing is not the same thing as it staying the same. Very good.
Thank you, teacher.
Very good. Okay.